Welcome to Child Rights Art Education Series with Olakunle Sanni, also known as Friend of the Child. On today's edition, we'll be looking at Section 28 of the Child Rights Act under the Part 3, which has to do with the protection of the rights of a child. Under this section, Section 28 talks about the child labor. And specifically under this Section 28, it speaks directly to prohibition of exploitative labor. Prohibition of exploitative labor. Subsection 1 of Section 28 says, subject to this act, no child shall be subjected to any forced or exploitative labor or be employed to work in any capacity except where he is employed by a member of his family on light work of an agricultural, horticultural, or domestic character, or C, required in any case to lift, carry, or move anything so heavy as to be likely to adversely affect his physical, mental, spiritual, moral, or social development. Or D, employed as a domestic help outside his own home or family environment. Subsection 2 says, no child shall be employed or work in an industrial undertaking, and nothing in this subsection shall apply to work done by children in technical schools or similar approved institutions if the work is supervised by the appropriate authority. Subsection 3. Any person who contravenes any provision of subsection 1 or subsection 2 of this section commits an offense and is liable on conviction to a fine not exceeding 50,000 naira or imprisonment for a term of 5 years or to both such fine and imprisonment. Subsection 4. Where an offense under this section is committed by a body corporate, any person who at the time of the commission of the offense was a proprietor, director, general manager, or other similar officer, servant, or agent of the body corporate shall be deemed to have jointly and severally committed the offense and may be liable on conviction to a fine of 250,000 naira. So that is Section 28, which speaks to prohibition of child labor. And then it's saying that because child labor, it's a violation of the right of the child, and like we said, it is there are different forms of child labor, and one of such is exploitative labor or forced labor, which has been talked about. And it is wrong as it becomes exploitative when somebody is taking advantage of the child and using the child for labor while the person is gaining something, maybe financially or otherwise. So it becomes an offense, and this section 28 speaks specifically to child labor, and it says that nobody for any reason should subject a child into forced labor or exploitative labor. That is, you tell the child to go and do the work and you are the one earning. For example, you ask a child to go out to go and work in the child is being employed in a shop to serve as shop assistant, and the child wants to work from morning till 10 p.m. and then at the end of the day, somebody still comes there to get the money that is meant to be paid for the child, and out of that money, that child is the one getting it. That child is just getting a paltry sum or maybe a very little sum from the money. So it said nobody should engage a child in exploitative labor or somebody or any kind of forced labor. That it also goes to say that nobody should employ a child in any work, in any capacity. or any kind of work that the child, except where this work, this employment or otherwise is coming from, is coming from the family of the child, maybe by the parent of the child, maybe in the course of trying to grow the child and make the child become self-reliant. Maybe the family has a farm, and then they think, okay, you can also be involved, instead of you can also be involved in trying to, maybe in the course of not, I mean, but they will not be made to do the one that's the job that are harmful. Maybe they will be assisting in picking the produce, on the farmland. And so it's also a kind of work which encourages and also build the capacity of the child to be able to handle such work when he or she becomes an adult. So it's saying that yes, nobody is allowed to employ a child into farm work, into all this work. But if it is a family member, then because you know that it is not done for exploitative purpose, it is for the well-being of the family, then that can be encouraged, but yet it must not affect the education of the child. It must not affect the development of the child. It must not affect the safety of that child. It must not affect the well-being of that child. So once it interrupts or it affects these things that I've mentioned, then it has become, even though if it isn't done by the family member, then it has become child labor. So, but it encouraged that the family can engage the child in agricultural, in their farmland, in horticultural practice, or in any domestic work within the home. And that's why subsection C goes further to say that yes, in any case, that this work that the child must be do, even if the child has to do any work within the family environment, I mean that this work must not require that the child must lift or carry anything, or do anything that is dangerous to his health, or move anything that is heavy, that is likely to cause adverse effect on his health. After the child must have picked the produce, for example, on the farmland, then maybe we now ask the child to now carry it. No, that is not ideal. That is not ideal. Even though you are the father or you are the mother of the child, it's saying that once it gets to that work, that part, it becomes exploitative and it's become child labor. So it's saying that except if the work is light on the farm, then it can be encouraged. But once the work and it's going to affect the health of that child, or the safety, or the spiritual well-being of that child, or the social development of that child, then it becomes dangerous. And it also goes further to say that no child should be employed as domestic help outside their home. So that's why there is also the NAPTIP Act, which specifically speaks to the age of allowing a child going to stay with another family member, because we know that over the years this child may be engaged in domestic work in other homes, and then that may become exploitative. And so in order to guide against taking your child to another family member for exploitative purposes, then that law also serve as a check. But this section 28 is also saying that nobody should employ a child as a domestic help outside his or her family home. That means the child can do domestic help within home, because that is one of the upbringing, that is one of the responsibility of parents, that they must give domestic work to children. But those domestic work, like we said, must also be friendly to the well-being of the child, must also be good to the development of the child, must allow the child to develop socially and morally, and must also be the type that encourages safety. I mean, that add to the safety of that child. And so, if anyone, so he's saying that nobody should employ the child outside his or her family or environment as domestic work. So, and we're talking about a person below the age of 18. So, subsection 2 now goes further to say that no child shall also be employed. Child shall be employed in a work environment. I mean, in an industrial setting. On an industrial setting, then so all these children that you find in factories, no child should be working in factories, for Christ's sake. No child, for the sake of God, no child should be found working in a factory. It is dangerous to their health, to their safety. It endangers their safety. It is dangerous to their even development, because they have to have they get to have a mindset of you having needing to do the hustle work, the strenuous work as a child. While as a child, they're supposed to be doing certain things that will aid their development. When it's time for them to do the strenuous work, they will be ready to do it at that time. So so this section is saying that no child should be employed in industrial setting, in any kind of industrial setting. And it's saying that this section does not apply to to work done by children in technical school, in vocational centers, like in vocational schools, approved vocational centers by government. So it means that, because when we talk about technical schools, there are a lot of machines that children are being taught how to use, because it is a technical is a technical center. And so, but this is quite different from a child working. And because the first one is the industrial setting, is talking about a child working, but this one is talking about that nothing in this section affects the learning of a child. The child should be allowed to learn. It is allowed that a child can learn, even though they are using some machines, but with the supervision of adults or specific authorized persons. Then a child should. This section does not in any way say that a child cannot use these machines or equipment in this technical school. So nothing in this section affects the technical school. And it goes further to now talk about the punishment. Now, any individual who violates this subsection 1 and subsection 2 that has been earlier mentioned, then that person may be imprisoned for 5 years, or even given a fine of 50,000 if found guilty, or even to both of them, both 50,000 or 5 years imprisonment. That's what this section says. And it says that even if an organization is found to be guilty, like in the case of industrial, maybe an organization is found to have employed children in their distance. So this subsection 4 goes further to now say that this individual, the proprietor, that is the owner of the organization of that industry, or industrial company, the owner of maybe the director or the head or any other person, will be joined will be assumed to be an accomplice in this case. So that means it's not going to be just the entity that is going to be sued. There are some certain individuals in that organization will also be sued along for violation of the rights of the child. And it's saying that a fine of 250,000 naira may be given to that child. But there is an extension to this, and only the court has a better way of interpreting these laws. Like I've said, I'm only doing my own part to educate ourselves as a lay social worker and a lay person, so that we understand the provisions of this act, so that we don't run against it. We don't want anybody ending up violating these rights, rather protect these rights of these children. Thank you very much for joining me. Please ensure that you subscribe to my channel by give us keep subscribing, keep sharing this, share it as far as you may like. Please also make sure that you like this section that we have just posted, and also please ensure that you leave a comment. Let's talk about this. If you have anything that you don't understand, or you need more clarification, or you have other opinion, even though yes, this is a law, it is stipulated already, until it's changed. That is the law. That is the provision in this Child Rights Act, and so it has become a law in this country. So, but yet we can always contribute and say, maybe contribute our position or how we feel. Maybe the punishment is light, or the punishment is good enough, or maybe the punishment is not enough, so that even if there's ever going to be a review, then maybe if they call on somebody like me or our colleagues, we can always contribute, put together some of your comments and make this contribution, so that the lives of children can be improved. Thank you very much for watching and listening. Please, like I said, please do ensure that you like, share, and also subscribe to this channel. God bless.